Hello everyone, today I'll be sharing another legal story with you. So what happened on 9 September 2025 is that the Supreme Court was dealing with the case of Pradeep Kumar K. Sarvani versus the state of UP and another. To understand this case, let's go into the background of the case. So basically, in this case, the magistrate, he issued a summon against the appellant with regard to the offense of rape on false pretext of marriage. Okay. Later on, the appellant, in order to sort the quashing of this summon, he went to the Allahabad High Court under section 482. The Allahabad High Court refuses to quash the summon. Okay, and against the decision of the High Court, an appeal has been filed before the Supreme Court. Right, the appellant or the accused, before the Supreme Court, he submitted that he and the complainant, okay, they were in a consensual relationship, and when something went wrong, they decided to part ways. Okay, they decided to part ways. Okay, the complaint or the FIR was filed 4 years after this. Right, so the appellant or the accused questioned the veracity of this FIR as it was filed after the delay of 4 years. Supreme Court set aside the decision of the High Court and quashed the summon issued by the magistrate. So the Supreme Court quashed the summon. Okay, the Supreme Court was of the view that the magistrate committed the error in passing the summon order, and the High Court overlooked the relevant aspect while rejecting the Section 482 application. Okay, it also appeared on plain reading of the complaint that the allegation made by the complainant do not inspire confidence, and there is no good reason explained for the delay of 4 years in filing the FIR. Okay, the court in this case laid down the steps to be considered by the High Court while hearing the quashing petition under section 482 of CrPC. The first is that whether the material relied upon by the accused is sound, reasonable and indubitable. Indubitable means that the material is unquestionable. The material that is relied by the accused is so sound in itself that it cannot be questioned. Okay, second step is whether the material relied upon by the accused is sufficient to reject or overrule the factual assertion contained in the complaint. So the whether the material that was relied by the accused, right, is sufficient enough to overrule or to reject the factual assertions that is made by the complainant in the complaint. Okay, third, whether the material relied by the accused has not been refuted by the complainant or it wasn't justifiably refuted. Refuted means to prove something wrong. Okay, and whether the material that is relied by the accused has not been proved incorrect, or it wasn't justifiably proved incorrect, right, by the complainant, right. And the fourth question is whether the proceeding with the trial would lead to the abuse of process of court or would not serve end of justice, right. Whether if they continue to proceed, whether it would be the abuse of process of court or it would not serve justice. Okay, these are the steps that are led by the court in order to ascertain the quashing petitions under section 482 of CrPC. If the answer is in affirmative form, okay, then in that case the petition is to be quashed.